Hi, I'm Jacob Stein. I'm an asset protection attorney in Los Angeles, California. And this is a quick and to the point video on the asset protection fundamentals. So what is asset protection planning? What are we trying to accomplish? What is this area of the law all about? The title of it may imply that asset protection planning is about protecting assets, right? Asset protection. Well, when you start practicing in this area, you learn that there is really no way to protect assets sort of in a bulletproof way, right? There are very, very few structures, maybe like two, where we are able to tell our clients that their assets are 100% protected from claims of creditors. So if making assets unreachable is not in the cards, what is our goal? What is asset protection all about? Well, I'll give you a very quick client story as an illustration. The client is a doctor, sits on the board of a nonprofit, and there are 4 other doctors on the board of this nonprofit. The nonprofit interviews lots of different people to hire an executive, and they finally hire someone they think is highly qualified to be the CEO of this nonprofit. One of the people they interviewed and did not hire filed a racial discrimination lawsuit, alleging that they were not hired because of their race. The lawsuit is filed against the nonprofit and each of the 5 directors, and they're all doctors. So this doctor comes to me and says, Jacob, this frivolous lawsuit, I'm not worried about it. But it sort of opened up my eyes. Bad things may happen, tomorrow I can get sued by a patient for malpractice, tomorrow I can get run over a pedestrian. So before something serious happens, let's protect my assets. So we set up some of these wonderful magical structures that we cover in other videos and elsewhere on our website to protect his assets. About a year goes by, and this frivolous lawsuit is concluded with a judgment for the plaintiff, $5 million. And this is a real case. $5 million judgment against the nonprofit and each of the 5 directors, joint and several liability. The nonprofit has about $1 million of insurance coverage, and the plaintiff now goes after the doctors to collect the remaining $4 million. Except they do not go after my client. Why is that? Well, there's a good old joke on point. You probably remember it. 2 guys are camping in the woods, a bear comes out. One of the guys sits down, starts putting on his running shoes. And his friend goes, "Why are you putting on your running shoes? You can't outrun the bear." And the other guy goes, "I don't need to outrun the bear. I just need to outrun you." This is exactly the same fact pattern, right? We were protecting our client's assets after the lawsuit was filed against the client, right? And given the outcome, maybe the lawsuit was not so frivolous. We did not need to make our client's assets unreachable. We could not have made his assets unreachable. All we had to do was make his assets more difficult and more expensive to get at than the other co-defendants. Because the plaintiff will always follow the path of least resistance. What is the easiest, most economical way of collecting on assets? Right? Even when we are representing someone who is the only defendant, the only debtor, that economic analysis doesn't change. If we can make it difficult enough, if we can make it expensive enough, we change the plaintiff's analysis of the case. And what will happen? Well, the statistics that we have from our practice are the following, and these are statistics that I have compiled over approximately 3,000 asset protection transactions. In about 30% of cases, when a plaintiff or a creditor is confronted with an asset protection structure, they will simply walk away. They will not pursue our client, they will not go after the client's assets, they just walk away. Of the remaining 70%, about 98% of the time, the plaintiff will settle with our client, but now they are settling on terms a lot more favorable to our client. And then the remaining 1 to 2% of cases, will the plaintiff try to go after our client's assets and penetrate the structures that we have set up? Sometimes successfully, sometimes unsuccessfully. Right? So the goal of asset protection planning is rarely to make assets unreachable. That's just not in the cards. The goal of asset protection planning is to make it more difficult or more expensive or both to go after our client's assets. That's the goal. So whenever you read about asset protection structures, please keep that goal in mind. Right? There is no magic wand. There is no silver bullet. How can we make assets more difficult and more expensive to get at? What about hiding assets? Is hiding assets a good way of protecting them? And this is a question we get asked a lot. This is what I refer to as the Home Depot method of asset protection. This is where our client, being sued, is afraid of a judgment, sells all of his assets, converts them into cash, goes to his local Home Depot and buys a shovel, right? And then he proceeds to dig a hole and bury the cash. Is this an asset that a plaintiff can take from him? Well, the answer is it depends. This structure works only if our client is willing to perjure himself. Because one of the remedies available to a creditor is to pull our client into a debtor's exam, right? In a courtroom-like setting, our client has to answer the creditor's questions about his assets, about the transfers of assets, and he has to answer these questions under penalty of perjury. Right? And we do not want to place our client in a position where they will have to perjure themselves for the asset protection planning to work. Okay? So we always assume that the creditor will know exactly what we have done to protect our client's assets. And our structures still have to work. So hiding assets, secrecy, it's not a bad thing, right? Because if the plaintiff never finds our client's assets, maybe they will never file the lawsuit. Or maybe if the lawsuit has already been filed, if they don't see any assets to go after, they're more willing to settle. But this is not something we can rely upon for substantive protection. Now, what about placing assets sort of far away, transferring them to foreign bank accounts, to family members? These are usually structures that are the least likely to work. Transferring assets to your kids, that's a naked fraudulent transfer, very easy to set aside. And now, more importantly, your kids get named in the fraudulent transfer lawsuit. The transferee, the kids, are a necessary party in a fraudulent transfer lawsuit. You don't want to do that to your kids. You put money into a foreign bank account. Well, if the bank account is in a foreign country, but it's in your name, if you have control over that bank account, signature over that bank account, the judge here in the United States can force you to take the money out and hand it over to your creditor. So every asset protection structure means that there is a structure, right? There is a legal structure that has been set up. Trusts, LLCs, retirement plans, agreements between spouses. There are literally about 2 dozen different asset protection structures that are commonly used, right? And we want to take assets that our client owns and transfer these assets out of the client's name into some sort of a structure, into some sort of a legal vehicle, right? But we want to do it in such a way so that although the client no longer technically owns those assets, he has in some ways retained control over the assets. He has retained the ability to transfer the assets back to his name, and we've engaged in all of these transfers of assets without any tax consequences. So every single asset protection structure, from the simplest to the most complex, looks to do the exact same thing. Take an asset that the client owns and make it into an asset that the client does not own. This is Jacob Stein, and I hope you enjoyed this presentation on the fundamentals of asset protection planning. Thank you.